Gentlemen, now you've arrived on what could be described as an extremely important parliamentary day, where there is an enormous amount going on at very short notice, which is affecting the movement of some members of the committee. We are core at the moment, and we hope will remain that way. But some people are going to have to go, and I have to go in particular, because I've got some questions I've got to put on points of order and things of that kind when the second reading comes up. And because it may happen quite suddenly, I need to leave myself a little bit of leeway to get down to the chamber. So without making any more of that, I'm going to start straight off, if I may, with the first question to you, and thank you very much indeed for coming. It's deeply appreciated. This is a very historic time, and you are, as it were, the centre of gravity of the analysis that we're taking by way of evidence. So I'll start by saying, in the hope that you've had a chance to read what was said before by Catherine Barnard, because she gave evidence somewhat earlier, a few weeks ago. So in earlier oral evidence to this committee, Professor Catherine Barnard alluded to, quote, a lengthy legacy effect of EU law in the UK after Brexit. The EU Withdrawal Act 2018 ensures that the UK's domestic legal framework will be closely aligned with the EU on exit day, and gives retained EU law a special status. First question is, what do you consider will be the most important legacy effects of EU law after Brexit, and how enduring are these effects likely to be? That's the first question. The second one is, what implications do these legacy effects have for Parliament's scrutiny of changes to retained EU law after Brexit, and for how it might approach scrutiny of new EU laws and policies agreed after Brexit? And I know that Professor Armstrong has done some written evidence, and Mr. Simpson-Caird sent some in this morning, or yes. But first of all, may I come to Sir Stephen Laws and ask him if he might be good enough to address the first question, is what do you consider will be the most important legacy effects of EU law after Brexit, and how enduring are these effects likely to be?
I'm not sure I would want to express a view on what the most important aspects of it is. I think the general thing that is important is that we will retain in our system, so long as we retain the retained EU law, something that carries all the characteristics and features of European law that we've come to understand when it was actually part of UK law. But on the other hand, there will be no new additions, except so far as we agree that there will be no new additions. But assuming there will be no new additions, we will have a body of law that is frozen at the moment in that we leave, whatever that is. Keeping it in place at that moment creates the possibility that expertise in that area of law will decay over time, because it will become increasingly something of historic interest. It will be superseded by things that will happen, and we will go back to a system which is much closer to UK law, because there won't be new additions to it. And so I think it will last as long as we find ourselves, as a matter of policy, wanting to be compatible with particular bodies of EU law. I think there is a risk that what we will come to understand as EU law will become more and more difficult to find out. And so I think what there needs to be in due course, and it may take quite a long time to do it, is a process of reintegrating retained EU law into UK law so that it fits the system that everyone will be familiar with, which is the UK law as it survives after
with
we
the
leave.
proviso, presumably, that, of course, because on the principle that no Parliament can bind its successors, that the prospect of a change in the legal arrangements under the Withdrawal Act may well turn out to be possible, likely even, given circumstances where people decide as a matter of policy that they want to distance themselves further, particularly in the context, for example, of divergence in relation to regulatory arrangements. There may be a number of matters. It's really the general principle that I was mentioning, which is the binding of successor parliaments.
Oh, well, I think the effect of the Withdrawal Act, without any withdrawal agreement or future relationship that imposes new obligations on us, without that, the sovereignty of Parliament continues. I wouldn't accept that it's ever been taken away, because Parliament has always had the sovereignty to change EU law, and that will continue. What I'm suggesting is that sovereignty needs over time to be exercised, so that we are not relying on concepts and reasoning and forms of law that people will become increasingly unfamiliar with because they will no longer be new versions of it. I mean, I remember when I was a law student, I was taught about the effect of the Law of Property Act 1925, and in order to be taught about the effect of the Law of Property Act 1925, I had to be taught about feudal land law. But in fact, the understanding of feudal land law by 1969, when I went to university, was relatively... I mean, there was a lot of learning on it, but it wasn't a thing that practitioners sort of used in everyday business. And yet, in order to understand current land law, you had to understand this. Well, we'll be in a similar situation with EU law. There will be EU law frozen in 2019 or 2020 or whenever it is, 2022. And yes, it will tell us what the present law is, but it will increasingly become difficult to see how it's relevant to what we have.
Thank you very much. Look, Mr. Armstrong, would you like to, Professor Armstrong, would you like to add to that?
I think I would. I mean, I think one way of looking at this is quite a formalistic level, but I think another way of looking at this is just to look at the substance of the law, that is the legacy of the styles of EU regulation, which of course UK systems have adapted to throughout its period of membership. So in many ways our regulatory systems, whether it's medicines, aviations, other form, banking, have all adapted to a particular style of regulation, a style of regulation that is to be found in European law. And I guess one of the big questions will be for the future, what makes that change? Is it because domestic policy preferences will change for the future because future governments, future parliaments will exercise sovereignty and want to move in a different direction? Or indeed will the European Union itself decide to change its style, its way of doing things, whether because of its own reasons or under other international influences? So I think this question about the legacy is also at quite a deep level in terms of the substance and the style, the nature of regulatory policy and how it has been implemented and applied through the UK's public administration for more than 4 decades.
See a prospect of our moving back to the idea of I'm now going to use a technical expression, stare decisis, rather than the purposive rule in terms of interpretation of law. Do you think the judges are going to move in that direction?
I think our judges increasingly have to deal with legal rules that are perhaps very different from the feudal property rules or whatever they had to deal with in the past. That is to say, judges and indeed other regulators have to deal with a body of law that is necessarily purposive. That is to say, what is the risk, what is the activity that a regulatory framework is trying to manage, whether it's the safety of products, medicines, aircraft, etc. So the legislation itself has changed. Our rules have changed. They are inherently purposive, regulatory, and I think our judges are now well used to applying forms of interpretation which look to what is the underlying function of these rules. They are inherently functional, and that I think will have to carry on. Now, of course, it is up to Parliament to, if it wishes, to lay down instructions to the courts as to how to interpret.
Yes, I was just wondering. Because, I mean, if you go back in my lifetime, and it's quite considerable, I mean, I first became a practitioner in 1967, and in those days it was Maxwell's interpretation, if you remember the book. And of course now we've got Crason legislation, so you've got a completely different sort of approach, as it were. So I'm very interested in that, because I think that we can't just talk about EU law in the context of the body of law, it's also how the courts deal with it. That's really what I want to get at. I wonder if Jack Simpson-Carey has got any thoughts on that, or would you rather leave that to the academics, pure and simple?
Well, I was going to go back to your first question about the importance of the Withdrawal Act, if I could.
Yes.
So I think the most important thing about the Withdrawal Act, thinking about the sort of post-Brexit statute book and the scrutiny that might be needed, is that the EU Withdrawal Act doesn't actually make a decision as to whether or not the statute book should remain aligned or diverge from EU law post-Brexit. It's deliberately drafted in such a way, in my view, to actually leave those questions for a subsequent Parliament, and I'll give a couple of examples. So, for example, the correcting power cannot be used by an express limitation, cannot be used to maintain alignment post-Brexit with EU laws that are made after exit day. And obviously the thinking there was that the decisions on alignment or divergence would be taken by other primary legislation, and then the power was also limited so that major policy decisions on divergence or alignment couldn't be made using the power in the EU Withdrawal Act. So the thinking was that we would need other powers in specific policy areas, agriculture, fishing, to make those policy decisions on divergence or alignment. And I think why that's interesting is because it shows you that actually post-Brexit, even in a sort of no-deal scenario, EU law and policy scrutiny will be very relevant to the domestic legislative process, because you'll need to understand EU law and policy in order to understand the powers that are being introduced via subsequent primary legislation. So I think in that sense, what's interesting about the EU Withdrawal Act is the fact that it didn't make any decisions on divergence or alignment post-Brexit.
David, did you have a question you wanted to ask or not? No. So my next question is, what implications do these legacy effects have for parliamentary scrutiny of changes in retained law after Brexit, and how far it might approach scrutiny of new EU laws and policies agreed after Brexit? We've covered some of that just now, but did
I
you
thought
want
was
to
quite
add
a good
something?
recent topical example of this was this controversy of how the government would use legislative means to end free movement after exit day. So I think there you've got an example of the point I was making. So Section 4 of the Withdrawal Act converts the treaty rights that are directly applicable in UK law now, post-exit day. So the relevant articles, I think it's 35, I might be wrong about that, of the TFEU would be converted the day after exit day into a domestic legal right, which would be legally effective via Section 4. Now, if the UK government wants to remove that right, it'll have to pass some sort of legislative measure in order to remove it. And I probably imagine that was something that the immigration bill might deal with in one form or another. But absent that immigration bill granting a power to the government to do that, its policy choices were restricted. And I think that's a sort of example of what we were discussing, in that in order to evaluate government policy, you're going to have to understand how the treaties affect UK law post-Brexit. And the fact is that because the EU Withdrawal Act maintained a high degree of alignment, i.e. it took over all the directly effective rights in the treaties, you're going to have a knowledge of a lot of EU law, not just until the point that we make decisions via treaties or via domestic policy to diverge and remove those rights, we're going to have a high degree of knowledge of EU law and policy post-Brexit.
Right, so David Jones, would you like to take the next question, please?
Yes, thank you, Chairman. Section 19 of the Act provides that the Act shall not prevent the UK from replicating in domestic law any EU law made on or after exit. Would you like to speculate as to the reason that that provision has been included in the Act? And would you say it indicates a desire to maintain a high degree of regulatory alignment with the EU after Brexit?
Well, as the drafting, I suppose that's primarily directed at me. I mean, I think my answer to your first question is no, I wouldn't like to speculate on it. I mean, insofar as it is saying that Parliament can do what it likes by way of primary legislation, it seems to me to be unnecessary.
The interesting part of the question, the provision seems odious.
I mean,
unless it's put there to signal a direction of travel.
Well, I think it's probably there because there is a fear that something in the Act creates the impression that it can't be done. It can't be something, an impression that Parliament can't do it by primary legislation, because Parliament obviously can. So there must be a suggestion that somewhere in the Act there is something that suggests maybe that there is either a limitation in international law that Parliament can disregard, or there is some limitation on the exercise of the powers to make statutory instruments. But I have absolutely no idea what it is that prompted it, except maybe an excess of caution.
Could it not be more innocent than that? That just if the EU has a good idea, we want to imitate it. Equally, if we have a good idea, they might want to imitate us.
As a parliamentary drafter, I'm very keen on the maxim that drafters repeat tirelessly, which is that unnecessary material in statutes, as in human beings, tends to turn septic. So I think the drafting answer is, if it's unnecessary, it shouldn't be there. So I would like to think that some reason was thought why it was necessary, but I'm afraid I can't tell you what it is.
Perhaps to turn the question round, one way of thinking about it is, why is that there, but also what's missing? In the sense that if this is true, if it is true that there is nothing to prevent the UK from replicating or emulating aspects of European law in the future, where would the power be for that to actually happen? Because, of course, it's not contained in the Act itself. The Act, the deficiency power is not a power that extends to emulating or replicating future EU acts. One would assume that had the European Union Withdrawal Agreement Bill come before Parliament, that there would have been a power in it that would have allowed, by statutory instrument, the replication or adoption of EU rules by choice. But of course, we don't have that at the moment, and that is currently missing. One would assume then that any future changes that the Parliament was minded to emulate or replicate in domestic law would happen by primary legislation, unless new primary legislation is introduced to create the mechanism by which it could be done by delegated legislation.
Can I just come back on that? Because, I mean, what strikes me about this provision is it refers to the United Kingdom, which is why I wondered whether there was some international law thing which it was directed, although primary legislation can't affect the international law position. But to refer to the United Kingdom in the sense of making law in the United Kingdom doesn't seem to me make much sense, unless you're talking about the United Kingdom as compared with other states, rather than a constitutional institution in the United Kingdom that makes laws.
Dr. Simpson?
I thought, in my evidence, I referred to the Financial Services Bill, which I think is an example exactly of what Professor Armstrong was referring to, which is a bill which just basically contains a power which says if the EU makes changes to the financial services body of law post-Brexit, here is a power so we can keep our law in step, so we don't diverge accidentally, so that we don't, just by not passing legislation, because there's no longer a European Communities Act, that we don't just accidentally diverge, which may be inconvenient for those people who want us to, for practical reasons, need us to remain aligned with developments from the EU's legislative process. So I think that's exactly the point, is that the idea is that the government will, once the relationship with the EU is decided, will then introduce various powers, some which will maintain alignment in certain areas and others which will allow the government to diverge, if that's what the overarching policy is.
So it is pointing out a direction of travel rather than having any inherent function of its own.
Yeah, I suppose it's the point. My first point about the EU Withdrawal Act is I think it's clear that it's not making any decisions on alignment or divergence, because it was always, my understanding was designed to cope with all outcomes of the negotiations, including a no deal, and a deal. So it's saying, well, future parliaments will have to make those decisions, and Parliament will have to judge on a case-by-case basis whether or not maintaining alignment, for example, in financial services is a good idea or not. Which is, I think, why it's important for a domestic legislative scrutiny perspective that you have a committee that can look at these powers and say, okay, we're going to have a power which means that financial services regulation will automatically come part of UK law post-Brexit. What laws are the EU proposing in this area? So what discretion are we giving away to the government effectively to implement future EU law in a particular area? And I think you'll need EU law and policy expertise to be able to assess whether or not it's a good idea or not.
So future role for this committee?
Basically.
Can I come
back
on the answer to the second question? Because being a literal minded chap, when the chairman asked me to answer the first question, I tried only to answer the first question, whereas my fellow witnesses answered the second one as well, which is the implications for the committee. And it seems to me that there are a number of features that will determine what the role of the committee should be. The first is the relationship between UK law and European law, and there are at least three possibilities there. One is that there's a dynamic connection. The backstop provides a dynamic connection between certain provisions of EU law while it exists and UK law, and relies on the rather, in my view, meaningless distinction between an amendment and a new act or replacement. And I don't know the difference between those. In fact, I don't think there is one. Then there's the possibility of alignment. And there's probably a case between dynamic and alignment where there's an element of reciprocity. So we're aligned because the other side are offering something in return, and if they don't offer it, it's going to affect one way or another what people are getting here. So dynamism, alignment can change in one of two ways. It can either change because the EU are changing their rules, or it can arise because we are changing our rules and they will come out of alignment. It seems to me there's room for the expertise of the committee in both, certainly in dynamism, because that's what you've been doing, and in alignment, and in both sorts of change of alignment. And then there's the case where the EU are doing something and there is a policy implication because the EU, who are our neighbours or with whom we have some future relationship, are making a change. That's something we need to take notice of because it may affect us. And then on the other side, there is the mechanisms that are available to the UK government to respond to that. So there may be, for the dynamism provisions, be provision for the UK government to be consulted in advance on what's being done. Some of the machinery in the backstop does that. In my view, it's incompatible with the Belfast Good Friday Agreement, but it's there and it would need to be followed through, and you would have a role in scrutinising the government in their exercise of that, or maybe the Northern Ireland one would go elsewhere. Then there is the UK government may have a right of reacting to changes that are made where there's a loss of alignment or where they want to make a change of alignment. So that also would be there. And then there's where the fact that alignment is changing just has a policy implication as before.
Thank you. Kelvin Hopkins.
Professor Armstrong, you have described a post-exit transition period as, in your quote, a type of shadow membership requiring the UK as a whole to comply with EU rules. That's the end of the quote. The government has said it will, and again a quote, support and facilitate a parliamentary scrutiny process for as long as EU legislation will continue to affect the EU. Do you foresee a continuing need for scrutiny of EU laws and policies during a post-exit transition period, and what would its purpose be?
Thank you. Clearly one of the purposes of scrutiny, that is the operation of the scrutiny reserve and what ministers do in their negotiations, falls away when the UK no longer has direct political representation within the Council. Nonetheless, because that the operation of the transition is one in which EU rules continue to apply to the UK and new rules will continue to apply to the UK during that transition, there is obviously good reason for a committee to have oversight and scrutiny and to monitor what is happening. Now, there's a certain practical aspect one has to bear in mind, which is that as currently drafted, and if the withdrawal agreement were ever to enter into force, that transition period ends on the 31st of December 2020. We have a new European Commission, a new European Parliament. It will be getting up and running. How much of what they would do that was new in that period that would become binding upon the UK during the transition period, you might think might be relatively small. Nonetheless, with the capacity of the Joint Committee to extend transition for 1 or 2 years, that clearly changes the picture quite significantly. There could be an entire 3-year or 2.5 years, wasn't it, at this point, transition period during which new rules could be proposed and enacted that would become binding upon the UK during the transition period. Again, that would then suggest that there is continuing and good reason to monitor what is happening at European level and what its implications are for that body of law which has now been domesticated and which is part of retained EU law in the UK. So I think the point I would want to emphasise is that, and this I think would be true even if the withdrawal agreement didn't enter into force and we didn't enter into a transition period, is that it will be important to monitor what the political and legislative programme of the new European Commission is going to be. Because whatever it does will have implications for British business. Divergence happening at their side, if you like, will still be important to understand for how our legislative framework, our regulatory framework is going to operate in the UK. And therefore paying close attention to those priorities, I think, will be a very important monitoring task. And as I think as I also try and emphasise in the evidence, that in fact philosophically the shift might have to be away from scrutiny for the purposes of scrutiny reserve towards a more active, dynamic monitoring of the regulatory environment in which the UK finds itself. And that is, of course, European because it's our nearest neighbour and our biggest trading partner, and because the legacy, if you like, to use my colleague Catherine's term, is so great. But also that extends, I think, beyond Europe to globally and where Europe fits within the global regulatory environment. So this shift, I think, philosophically is from scrutiny to monitoring the broader policy implications of alignment and divergence.
Thank you.
Just come back on that particular point, Professor Armstrong. Shouldn't that monitoring task actually be undertaken by the British government rather than by a parliamentary committee?
I think what is important from a parliamentary perspective is, of course, one will always want to know why it is the government wants to do something like emulate or replicate those rules in domestic law, or decide that it doesn't. What is the policy implications of that? Are they well thought through? What does that mean in terms of the conduct of regulatory policy in this country and its implications for citizens and businesses in this country that you, as parliamentarians, you represent your constituents and who will be affected by that. So I think it is absolutely right that government monitors those dynamics and what is happening. But I think it's also important that there is a capacity for Parliament to undertake its own independent monitoring and to work out whether government is actually keeping its eye on the ball, keeping its eye on the target. Is it really seeing what is happening out there and responding appropriately and accordingly? And I think that's manifestly a task for a parliamentary committee.
A committee to monitor the government, what the government's doing effectively, to make sure we keep an eye on them. Are there particular policy areas in which Parliament should focus its attention during the post-exit transition period, and are there others which might be of less importance?
It will be a very interesting time, I think, to be undertaking this exercise. I think if we look back at the last Juncker Commission, obviously so much of what it was doing was tied up with crisis legislation and dealing with the aftermath of financial crisis and then migration crisis, etc. This Commission, I think, will be, if it can, will be much more forward-looking in terms of thinking about where the European Union wants to position itself over the course of the next the next decade, and therefore I think the sort of that will be about completing some of the activities that the last Commission was doing on things like financial services and banking and where monetary union goes in the future and how it relates to financial services. There'll still be that, but I think there may be other kinds of agendas out there that will be important. Much of the EU rulebook, if you like, is already relatively settled, and in fact, much of the EU's activities, as we see from from previous commissions, is now moving into a more post-legislative phase, the kind of delegated rulemaking, statutory instrument side of things at an EU level to keep everything up to date. Now, as I think this committee has rightly noted, for you to try and monitor that sort of delegated and implementing acts would simply swamp you. It would be also might not be terribly interesting. So I think keeping an eye on what we will see actually relatively soon in November, when the new commissioner, new commission president sets out what will be her legislative priorities. I think that will give you a good indication of the sorts of things to monitor. And it might be very different from the more routine aspects of the internal market and its operation than perhaps we've all become quite used to over the last 20 or 30 years.
Third question, how might scrutiny need to change given the UK's lack of representation and voting rights within the EU institutions after Brexit?
That's an important question, I think, because it shows that whatever arrangements you come to, they'll have to be flexible, because whatever Brexit scenario I think we have immediately after exit date, it's likely to change then quite quickly in the period afterwards. So I think whatever scrutiny arrangement you come to post-Brexit will have to be adaptable, and obviously one of the good examples of that is transition. And I think the basic point, which I think we've already sort of covered to an extent, is even absent the scrutiny reserve function, from a rule of law perspective, there's real value in terms of the work of the committee in terms of making the legislative process more transparent, because these are very difficult technical exercises, and the work of the committee is to essentially, as I understand it, to make the legislative process more accessible by synthesising and summarising it and then making it subject to political debate that otherwise would not happen if it was just undertaken in government. There wouldn't be a political debate on changes to the law that are going to affect all people in the UK. And obviously I think there's a real rule of law value in terms of the fact that there's a committee in the democratically elected House that actually undertakes this work to make sure that the legislative process is as transparent as possible. So I think in principle, even absent the scrutiny reserve, there is a case for that work carrying on. But I think obviously I agree with Kenneth's point that over time that will obviously shift to a monitoring function post-transition. And I think the other point I wanted to make about the scrutiny reserve is that there's obviously a case, I think, for adapting the scrutiny reserve to some post-Brexit functions. We've already mentioned the joint committee potentially, and how you could how that could be adapted to the UK government's position in the joint committee. Then obviously there's, I don't know, it wouldn't necessarily be the scrutiny reserve, but you'd want to adapt the functions in terms of the domestic legislative process, working out the government's position, how the domestic legislative process affects its position at the EU level when it's negotiating with the EU. And then obviously the big one would be the scrutiny reserve as it might affect the negotiations themselves and what the UK's government's position is in the negotiations. And having an understanding of what's going on at the EU would be vital to scrutinise what positions the UK government is taking in the negotiations.
I have to say that this committee is taking a strong view that there should be an ongoing committee of a slightly different type following after Brexit, and that there should be a strong parliamentary role in looking at the EU afterwards. It occurred to me also there's an organisation called COSAC, which is the parliamentary, it's the national parliament's representative body that meets a couple of times a year, and some non-member states have observer status at these things and can make contributions, and I would have thought that Britain could do that as well. Anyway, that's my thoughts. Thank you, Chair.
Martin Day.
Thank you. Professor Barnard had told us that the repeal of the powers contained in Section 2, Part 2 of the European Communities Act 1972, and her quote is, may be very inconvenient for the government where it wants to actually give effect to a piece of EU legislation, and that there might have to be some legislation that reenacts something like that section. So what is your opinion from a rule of law perspective regarding that as to being a useful tool for government and parliament?
I think this goes back to the point we were making earlier about the way in which Section 2.2 has been a very flexible instrument during membership that has allowed the UK to use statutory instruments to incorporate EU obligations in a very straightforward manner. Once you take that away and you want to amend the retained EU law, not correct deficiencies, but simply amend it in light of changes at in the European Union legal framework, which fully align with UK domestic preferences. How would you do that? There is no such power in the 2018 Act. I speculated that the European Union Withdrawal Agreement bill might have wanted to contain such a power to provide for that very capacity. Otherwise, the only other option is to have the kind of sectoral legislation that Dr. Simpson-Caird identified in the financial services realm, the bill there that would have allowed that in-flight rules to be that would amend domestic retained law to be incorporated using a Section 2.2 similar type of power. But I completely agree that absent that power, once that power disappears when the European Communities Act is repealed, it would be highly desirable to have an instrument and a mechanism that would then replicate that. And of course, from a scrutiny perspective, it would be important to know how and when that power was being used in terms of the scrutiny of delegated legislation.
The rationale of Section 2.2 is that it is used for implementing obligations. So we are required to do it. And so that there is not so much pressure on what you're doing. It's more a question of whether and how you're doing it. And that's the reason why it is thought legitimate to take a very wide power for implementing it, because a lot of the questions that might arise if you were enacting things from scratch don't arise because you've got to do them. Necessarily, if we are changing EU law in circumstances when we aren't subject to an obligation, that justification doesn't exist. And that's why I think the system that the 2018 Act envisages is that if we make a decision that a particular area of law needs to be kept aligned, we shall take a power, as Simpson-Caird mentioned in relation to financial services, we will take a power that is confined to that area and will effectively commit ourselves to alignment. There are going to be other cases where we want to keep in alignment, but it's not a commitment. It's a temporary alignment in relation to something that changes very regularly, the standards or approved standards, or is changed by administrative means. In those circumstances, it is going to be very inconvenient that we won't have the power to express something, because you have to do it rapidly to keep it in line. And there the government would presumably seek to justify a power, perhaps sunsetted, if it didn't want to say, well, we're always going to keep this in alignment, that would enable it to keep something in line where there are very rapid changes and it's not practical to think that you could do it regularly by primary legislation.
I just want to add something there, that I think there may be some rule of law concerns which are often raised in the context of delegated powers, that if you had, it would be suboptimal to replace the broad power, which is, as Sir Stephen was saying, which is based on an international law obligation, which then gives the UK the power to make representations at the EU level, to replace that with a situation where you have lots of powers that are exercised by the government without a commensurate increase in Parliament, the UK Parliament's involvement. So, i.e., if you're moving from the system we have as a member state to the system where we're not a member state, and the answer is just more delegated legislation without a commensurate increase in the supervision in Parliament of that legislation, I think that you would say that that would be, on balance, a diminishing of the transparency of the legislative process, because effectively then you've just, you've taken something which was a product of a longer EU law process where there was democratic input at the EU level and then at the UK level, and you're just replacing it with a system where you have a whole range of complex powers at a domestic level, which, as we know from the statutory instruments going through at the moment to prepare for EU exit, it's not easy for Parliament to scrutinise. So I think that might be quite a concerning scenario from a rule of law perspective. And then obviously the question of the courts as well there, that if you're relying more and more on delegated legislation, which isn't supported by a treaty obligation, then you might give rise to more challenges in the courts.
Thank you. More discussion.
Thank you for that. We've touched on the joint committee already briefly, but do you believe that Parliament should put in place special scrutiny arrangements for the joint committee if one is established, the body which is responsible for overseeing the implementation and application of the withdrawal agreement?
There, with the sort of major headline, I'm not an expert on the joint committee, but as I understand it, Professor Armstrong will correct me, the joint committee has the decision on the extension of transition, for example. Is that correct?
Yeah.
It does. So a major decision like that, it would seem very odd if Parliament didn't have some kind of special power in relation to the UK government's position on whether or not to seek an extension of transition at the joint committee.
And I think moving on from that, I mean, the joint committee does have really quite extensive powers to manage the operation of the withdrawal agreement, to adopt decisions and recommendations, decisions which are binding, decisions which can even change the terms of the withdrawal agreement in certain respects. And therefore, that activity, how that activity is being carried out is, I think, quite significant. What is worth, I think, looking at in particular is the role of the Joint Committee under the Irish backstop. It is clear that instruments which amend those pieces of legislation which the withdrawal agreement says will apply, that those will automatically apply. New instruments, however, may also apply. New instruments that are adopted if the backstop is triggered will also apply. But there is a mechanism by which there will be an exchange of information. The drafts of new instruments will be communicated, an exchange of information over, I think, a 6-week period. And in fact, there's a subcommittee, or there's in fact it's even more than that. There is a specialised committee, and below that, a working group or working party which advises it, which is designed to highlight any problems that may emerge between the two sides in terms of the adoption of new EU instruments which would become applicable to Northern Ireland if the backstop was triggered. And there's quite a structured process of providing information and exchanging information, which I think obviously a committee would want to monitor. But I think what is important about that is that sort of structured cooperation is missing under the ordinary transition period. And given that that could last for 3 years, or 2.5 years, that could be quite an extensive period of time in which new EU rules could become applicable to the UK, but without the same structured process of dialogue. Now, we know that the withdrawal agreement does say that this Parliament will retain the status of a national Parliament for the purposes of delivery of Commission green and white papers, consultation documents, and draft legislative proposals. So that will remain in place. But nonetheless, I still think that the Joint Committee's function is an important one, and that I think it would be interesting for this committee to explore how it might want to monitor its activities.
Well, I broadly agree with that. I think we've already discussed the fact that the role of this committee would be to exercise the parliamentary, or to be the lead on the parliamentary scrutiny and accountability of the government for managing the relationship between EU law and UK law. And I mentioned that has two aspects, that how the connection exists and also the mechanisms, and Professor Armstrong's mentioned some of the mechanisms by which the UK government can involve itself in what's happening to EU law. And so it seems to me clearly that would be a matter for the committee to exercise its scrutiny and accountability role.
Chair, I just wonder if I could jump in there, because if it's relevant to a question I was going to ask a bit later on Northern Ireland. I just wondered, in the context of Northern Ireland, if we need to, do you think that we would need to align ourselves in order to preserve North-South cooperation with EU law to some extent, whether you need a binding treaty to do that? And if so, what would you propose similar sorts of structures for proactive scrutiny and committees to help do that, or not?
I've already indicated that I think one of the problems with the backstop is it imposes mechanisms on the process of alignment that are incompatible with the strand 2 of the Good Friday Belfast Agreement, because there are a whole load of mechanisms for reaching agreement on cross-border issues between the North and South that have been superseded by the mechanisms provided for, or would be superseded by the mechanisms provided for in the backstop. So I think my answer to your question is, I think so far as Northern Ireland is concerned, the most important and first point of scrutinising the relationship between EU and UK law should be the mechanisms provided for in the Good Friday Agreement, and the burden should be on the Republic to make sure that they are able to operate them.
Returning to the Joint Committee and the work of this or a similar committee, do you think that there should be a process similar to the scrutiny reserve, under which the government would need to obtain consent before agreeing to particular measures pursuant to the agreement under the working arrangements of the Joint Committee?
I think one can certainly see an argument on the question of the extension of the transition period. I think that is quite a significant political issue, and that is a decision of the Joint Committee, and it's right that this Parliament holds the government to account in what it does there. I'm not sure, though, that is necessarily about scrutinising the Joint Committee per se, although it's a decision that will be taken in the Joint Committee. Decisions of the Joint Committee are taken by consensus. So that means both sides have a view and you have to make them match. So scrutinising what the UK government does happens would happen anyway. More on the more day-to-day operation of the joint committee. Given how wide-ranging its powers might be, it might prove to be difficult to scrutinise it. But I think it would be. I think it'd be very important to try and to establish means of communication, so there's at least transparency, clear transparency in the agendas of the joint committee to know what is coming up. And there may be certain elements of that could be subject to a scrutiny reserve that would be clearly of such political significance that they would require this House to be able to consider the position that the government would take before the government then acted within the joint committee.
Marcus Fish.
Thank you, Chair. Yes, I just coming back to the reactive and proactive monitoring and Northern Ireland. I just wondered if there was going to be some sort of a pre-commitment to alignment with EU rules within the framework of a, as you say, another agreement that was to sort of preserve north-south cooperation. What are the effects on things like adequacy decisions, for example, with respect to data? How would that be best organised from a scrutiny perspective?
That's a difficult question. I mean, on the adequacy decisions side of things, I know this is something that the exiting the EU Select Committee has looked at and reported on, I think. I can't remember if it has something specific in respect of Northern Ireland. As far as I recall it simply discussed adequacy decisions, transfers of data in the wider context of trade negotiations and how long it may take for adequacy decisions to be given. And to be honest, I'm not sure I could express a view beyond on that specifically. But I think on the question though about pre-commitment to alignment, because of course that could be something that goes beyond the backstop itself. I mean, this could be something which a future government may decide that there'll be much higher levels of pre-commitment to applying EU rules, not just for the purposes of securing frictionless trade north and south on the island of Ireland, but frictionless trade between this island and the rest of continental Europe. Now, we have a model for this. It's called the European Economic Area Agreement, and we know what that there are scrutiny arrangements in place there precisely because there is pre-commitment to those rules. And I think one of the big lessons we learn from all of that is just how important it is to create very strong parliamentary contacts. I think Mr. Hopkins mentioned the COSAC as one, but of course EFTA and the EEA agreement have their own parliamentary groupings where there is cooperation there. And importantly, some of the same members of the equivalent of this committee in Norway are also members of and delegates to the relevant EEA parliamentary body as well. And what is important about that is creating that flow of information, that level of contact, which allows actual scrutiny to operate effectively, because it means that you're not having to wait for somebody else to provide you with information. You have your ears on the ground from where that information is coming. So I think whatever arrangements are in place, having ears on the ground becomes important.
And is it as important if you have a system of voluntary alignment rather than such pre-commitment? Is it as important to have these scrutiny mechanisms and flows?
I do think it is for the reason I think I gave earlier, which is that, and I think one of the things that has come out from this session already is there's one set of questions about why would UK policymakers want to diverge from EU rules and what scrutiny you would want to have of domestic political processes and what happens to that, the legacy of retained EU law. And on the other side, there is what happens when the EU diverges from us and by enacting new rules, changing the system. And either way, even if we don't have pre-commitment to align, understanding what is the policy implication of that change is crucial. And one of the things that I've tried to draw out in my written evidence is that there will be a set of questions about how legal frameworks operate, technical questions, and also certain rule of law questions about the complexity of the legal frameworks that we will have inherited and which we will then be building upon in the future. Now, how that system operates in a kind of ex post scrutiny way almost, I argue might be something better undertaken by the elaborate committee system of the House of Lords to ensure that it has a strong legal eye on the technical operation of the legal frameworks. But to answer your question, I think there's a very strong policy implication of divergence, of why the EU might move away and develop new styles of doing things or take different approaches, which is incredibly important for the UK to understand from a policy and political significance point of view, which is why I underline the point that I think we then move into a different era of scrutiny that is about monitoring and is about determining political and policy significance, perhaps a little bit more than legal relevance and the technical interaction of legal regimes at a European and domestic level. Sorry, that's a very long answer to your question.
I mean, I would say that what's important for scrutiny and accountability to concentrate on are those things that have political salience. And there are two ways in which you guarantee that you've identified those things. One is to impose requirements that make it transparent what is happening, and so you can identify it yourself. And the other, which is what I say in relation to all sorts of scrutiny, including primary legislation, is to have some sort of system, which in practice is all you can do, of random sampling, so that you can identify from time to time the things that are politically salient. And sometimes the technical matters that Professor Armstrong's mentioned can themselves become politically salient. The example I sometimes give of that is the tax law rewrite project, which was formed when tax law was thought to be getting so complex that it had become politically salient and something needed to be done about it. So what is normally important in this House is things that are politically salient in respect of what the effect they have on people. In the House of Lords, the technical matters may be more politically salient than they are here, but sometimes they can become salient here as well.
I just want to add one thing in terms of your distinction between what the scrutiny needs would be if you had voluntary alignment or pre-commitment by treaty. I think with voluntary alignment, thinking about it, you're more likely to have controversy at the domestic legislative level, and therefore I think that you'd want that you need the EU law and policy scrutiny expertise to analyse what's going on when the UK is passing that legislation designed to maintain domestic alignment, to actually work out what's going on, because it's going to be quite complex and again rely on delegated power, so it may not necessarily be immediately obvious. So it's from a transparency perspective, you would need some EU law and policy expertise to see, well, this bill is designed to maintain voluntary alignment. I think there you've got to think about the fact that when you've got it on a treaty basis, as I understand it, the EU Scrutiny Committee works upstream at the EU level. But if you're going to a voluntary alignment model, the work of the EU law and policy scrutiny is going to occur more at the domestic legislative level. I think that's the point.
And is it fair then to say that because the I think the Northern Ireland Protocol says that that the North-South cooperation relies to a significant extent on common union legal and policy framework. I mean, is it fair to say that that depends? It really depends on what your scrutiny arrangements are and your arrangements for this type of thing in particular areas, that it would vary quite significantly in terms of how much it relies.
I think the modelling exercise that was done revealed that it didn't rely on it nearly as much as was maybe the backstop's terms suggested.
Yes. Because if you have a very efficient system of analysing what each other is actually doing and making appropriate adjustments and thinking about it, then you by definition rely on the commonality less potentially.
I think the issue may have been there. I've heard it said, and I'm not an expert on this, that the assumption was that there is a common all-Ireland market, and there isn't. I mean, there is in some respects, but not as in many respects as has been suggested.
Yes. Right. Down the hallway in committee room 5. Because I'm late for it now.
Well, in that case, I think I should say order at this point. Gentlemen, I can only apologise. As the chairman said, you've arrived on a particularly momentous parliamentary day, and I'm afraid that members of this committee who otherwise would have been here are not here for reasons which I'm sure we can all understand. And with Mr. Fisher's departure, we lose our quorum. So I'm afraid at this particular juncture I'm going to have to call this session of the committee to a close. But I'm very grateful to you for coming, and I do hope that you would be happy to take any further written queries that we were to send you afterwards, if that were convenient. And I do hope you understand the problems we've got today. Thank you very much for coming.
Thank you very much.